Good day, everyone. Welcome to the webinar, Help Us Help You Get Paid, 10 Things You Can Start Doing Today to Improve Your Commercial Reimbursement Success. As I'm sure you know, online access is being used more than ever during this time, and so the quality of the presentation may be strained at times. If you're experiencing sound or technical issues, please comment in the chat room and I'll address it once I'm done talking. My name is Angie Fiedler Sutton, and I'm with the Behavioral Health Association of Providers. The Behavioral Health Association of Providers, otherwise known as BHAP, is a national trade membership association that provides education and advocacy for behavioral health care providers and related entities. Formerly known as the American Addiction Treatment Association, BHAP is the leading and unifying voice of addiction-focused treatment programs. We provide membership opportunities such as networking and various benefits, educational opportunities such as this webinar and our Certificate in Addiction Treatment Marketing, the CATM, and advocacy efforts to keep those in the industry aware of new laws and regulations that may be coming that will affect them. Working in the behavioral health industry or managing an organization in the industry can be incredibly complex and filled with ever-changing information for compliance. BHAP gives you the resources to stay on top of the rules and regulations for your organization to stay compliant. For more information about BHAP, you can visit our website at www.bhap.us. Before we begin the webinar, a few housekeeping details for those of you joining us for the first time. You will be able to hear us, but we won't be able to hear you. That's because we record these webinars so you have access to them later if you need them. However, if you have questions or concerns, you can use the chat room on the lower left. You don't need to wait until the end for questions. We will be moderating them as needed. We will send a link to access both the webinar and the PDF of the slides via email after the event. And now, it's my pleasure to introduce our presenters today. John A. Mills is a partner at the healthcare law firm Nelson Hardiman. John's regulatory compliance work focuses on key issues facing providers that could potentially impede their business operations. He advises clients on managed care and ERISA compliance, voluntary disclosures of possible Medicare overpayments, medical staff and peer review, analysis of business arrangements to ensure compliance with the anti-kickbacks and Stark laws, and provides regulatory guidance to covered entities and contract pharmacies in connection with the federal 340B program. Zachary Rothenberg is also a partner at Nelson Hardiman. Zach has a breadth of knowledge in the behavioral health space. He advises drug rehabilitation facilities on land use, advocating for clients where administrative actions challenge zoning laws, attempting to prevent facilities from operating in their existing location. He litigates out-of-network and in-network reimbursement cases on behalf of the addiction treatment facilities and responds to special investigation audits. He has also advised on labor and employment defense matters, including those related to racial discrimination, wrongful termination, wage and hour disputes, and retaliation. Clients have come to rely on his insight regarding employee handbooks and labor code issues. John and Zach, thank you for taking the time to present today. With that, I will hand the webinar over to you.
Thank you, Angie, very much for hosting this and giving Zach and I the opportunity to speak to everyone this morning about these timely issues regarding reimbursement. It seems like it's always a timely topic, and it may be more so right now. Just real quickly, I want to follow up on a little bit what you indicated, Angie, about Zach and I and the type of work that we do. We, as you indicated, we're both litigators. We both spend a lot of time going to court, and we both spent a lot of time over the years battling with the insurance payers. So we know the reimbursement landscape very, very well. And I think, though, one of the things that helps set us apart as a firm and as a practice is that we're at a full-service healthcare firm. We represent all sorts of healthcare providers. We only represent providers. We're only on the provider side, but we represent a lot of different types of providers. So we've got a very good view of the entire healthcare landscape. And in terms of what we do as a firm, we do everything. We're full service. We do corporate, we do regulatory compliance, and we do litigation. And so that gives us a sort of keen understanding on some of the reimbursement issues that come up. For example, dealing with SIU audits and other types of investigations, because we have a criminal practice, criminal defense practice, because we regularly defend fraud and abuse disputes both with government and private. We're able to really jump into those areas very, very well. So that's all I wanted to say about our firm, but I thank you again for allowing us this opportunity to speak to the audience.
Hi, everyone. This is Zach. I wanted to give 2 seconds of sort of background on why we decided to offer this presentation at this time. We've been hearing from a number of our provider clients that business is a little rough these past few weeks, just like any other industry. Cash flow may be an issue, and one of the things folks can do, and this isn't unique to healthcare anyway, but one thing that folks can do when cash flow is tight is to pursue that old AR. And in the healthcare world, obviously, that means reimbursement. And it's sort of a good time to sit back and assess: am I owed money? Am I not being paid what I should be from commercial insurance companies? Are there outstanding balances out there that I should be pursuing now? And how do I even think about making that analysis? So we wanted to offer up a nuts and bolts, almost like a list of things to be thinking about, to be focused on in the short term, that can affect both your short-term reimbursement and set you on a path for the long term to do a little better with your collections from commercial insurance companies. So that was the premise, and time is short, so let's dive in here.
Zach, can I interrupt real quick?
Yeah.
You're coming in a little in and out. Just double check that you are closer to the mic.
Okay. Yep. Got it. Is this any better?
Yeah, much better.
Okay, good. So, number one, maintain immaculate intake documents. And a thing to keep in mind is that your documentation is what, in our world as litigators, is proof. And if it's not in writing, it can be awfully hard to prove. So there's a lot of things we're going to be talking about today that it has to do with documentation. And the basis of that documentation, in our view, is that it's proof. If it's not written down, it didn't happen. We'll talk about it with respect to medical records. And right now I'm going to talk about it with respect to intake documents. When we have to pursue payment, whether it's in court or before court, making demands to insurance companies, there are a couple of theories generally that we can use to seek payment. The first is if you're in network, a network agreement. That's pretty obvious, and I'm not going to spend really any time on that. But that is option number one for folks who are in network. As most of you know, behavioral health and in particular STD treatment is disproportionately out of network. So we're going to focus on that today. In the out-of-network context, there are really two primary theories. The first is based on an assignment of benefits, and that's documentation number one that you need to be focused on to make sure that you have an assignment of benefits, that your clients are signing upon intake each and every time. And I would also encourage you to have your attorney review that assignment of benefits carefully. We're seeing increasingly that insurance companies are taking a real fine-tooth comb approach to looking at your assignment and deciding whether that really gives the provider the rights to pursue payment from the insurance companies. We're seeing a lot of pushback from insurance companies to find loopholes in going line by line through assignment of benefits. So there are good ones and there are bad ones out there in terms of the assignment document. And you want to make sure that you have a foolproof, really airtight assignment of benefits. I'm going to leave it at that for now because it's sort of too particularized to get into in this kind of setting, but I would encourage you to really focus on that assignment and have it vetted to make sure you're using one that is going to serve you well down the road. If you're not using an assignment of benefits, the other approach we can use is through what's called an implied contract. And the concept here is that when you make these verification of benefits and authorization phone calls and discussions with an insurance company, you are creating a pattern and a practice over time of how you're going to interact with the insurance company. And so your activity over a course of time, days, months, years of working with a given insurance company in a particular routine way, is going to establish in the eyes of a court an agreement, just like if you had an agreement on paper a standard written contract that you might think of. It's the same concept. There's a meeting of the minds between the provider and the insurance company in terms of what services are going to be provided, and what the provider is going to be paid for those services. And the evidence to support that agreement is a number of things, but the two most important are your verification of benefits and your authorizations. And so I would encourage you to focus on those two activities and to document them as best as possible. In the verification of benefits, I encourage clients to have a script. And it can be almost like a fill-in-the-blank form that your staff will go through to make sure they're asking all the right questions each and every time, following up with the insurance company, who can be intentionally or unintentionally vague or cagey about how they're answering, to make sure that you get all the information you need. You want to put that information into the form and save it as a separate document each and every time, so that if you ever have to go back and figure out what was I told by this insurance company on this date regarding this particular client, you're going to have that information. Because I'll tell you, as a litigator, that's what I do all day long. I make sure that we have written evidence that's going to hold up in court to support this agreement that the insurance company agreed to pay for. So you'll want to focus on three basic questions. You'll want to confirm that there's out-of-network coverage for the services that you plan to render. You're going to want to understand what the allowed amount is, meaning the total amount that that is the value of the service you'll be performing, and how that dollar number is calculated. Usually it's something based on a percentage of bill charges, or what's called a usual and customary rate, or a UCR rate, or some percentage of a Medicare rate. Those are just examples, but they're the common examples. You're going to want to make sure you understand how that dollar number is calculated and that you've documented it. And then separately, you're going to want to understand the portion that will be paid by the plan versus the portion that will be paid by the patient, the co-insurance. And then second, aside from the VOB, you'll want to make sure you have documentation that you were authorized to perform the particular services that you are going to perform. Frequently, those are done in an authorization letter. But if you don't have a letter and it's done over the phone, you want to make sure it is documented clearly, concisely, in writing, in your own records, that you have a record of date it was made, who said it. Usually you'll get a name of the representative from the insurance company. You'll frequently get a number. That's the number for that call, the reference number for that authorization call. And you'll want to make sure you know exactly what services have been authorized and how many units. Because I can tell you, as someone who's litigated a lot of these cases, if you don't have those records, you're going to have a heck of a time proving that the insurance company ever agreed to pay you anything. Let's move on here. There. Okay. Number 2. Be careful with financial hardship and patient financial responsibility. Fee forgiving, as it's often called, is the low-hanging fruit for insurance companies. It's their way, oftentimes, of demanding a recoupment, and it's their way of refusing to pay, particularly once you get to litigation. And keep in mind that just because an insurance company hasn't complained yet about fee forgiving, or hasn't accused you of doing it yet, doesn't mean they won't make an issue of it down the road. I do a lot of labor and employment work. I liken it to an employer keeping an employee file. And I'm assuming many of you are employers. You know that it's a good practice to maintain a file for every employee that tracks all of their tardies or unexcused absences or any slip-ups. And one of the reasons to do that, and this is cynical of me, but it's true, one of the reasons to do that is if you ever need to make an adverse decision against it, if you ever need to fire them, for example, you'll want to make sure you have this documented record of all their bad behavior. The insurance company, I believe, is doing the same thing to its providers. It's keeping an employee file for each of its providers and keeping track of every little thing it can ever want to use against the provider in case it ever needs to. And what we find is when we ultimately take a case to court, is the insurance company will pull out that file even though none of these issues have ever been voiced before, for the first time say, well, look at all this list of things that this provider has done wrong over the course of the years. This is why we shouldn't pay them. And first and foremost, in my experience, is these issues with patient financial responsibility. So you have to make sure you're handling this issue in particular correctly. And so what are some easy ways to do that? Number one, best case scenario, of course, is to collect all of the patient's contribution up front and in cash. But we all know that that's frequently not realistic. And there's lots of ways to handle what to do if that's not realistic, whether it's through grace period, payment plans, securing a debt with a promissory note, etc. And those are things for you to think about. But one of the other most frequent ways is with a financial hardship policy. Lots of folks do it. It can be done correctly, and it can be done horribly incorrectly. And so the single most important rule for handling financial hardship policies is to have a policy, have a concrete written policy that you use every single time in terms of how to evaluate somebody for whether they have a financial hardship and how you're going to account for it. So what we usually recommend is having it be based on something like the federal poverty level, and having a sliding scale depending on their income and assets. You should never advertise the hardship possibility, and you shouldn't make it a matter of course. You'll want to document every step of the application process. You want to make sure your clients are filling out a form and signing it, that they are providing you documentation, whether it's bank accounts or W-2s or something like that to prove their income or lack of income, at least as best they can, because someday you may need to stand up in court and justify your application of that policy and say, look, patient number X, that person got a financial scholarship because they filled out an application, because they met our criteria. And then, of course, the other flip side of it is what to do if a patient doesn't pay. And the key there is commercial reasonableness. You'll want to make a cost-benefit analysis to ensure that you are doing what any commercially reasonable business would do to collect their debt. You often hear that as long as you send 3 demand letters, you're good. And I think that is a little bit of lazy thinking. And so what I encourage folks to do is to think, well, look, what would a commercially reasonable business do? If you're going to try to collect from somebody who you know is homeless and has nothing, it doesn't make sense to file a lawsuit against them. It's somebody in a different circumstance who has the assets and the resources and is simply just refusing to pay. Sending 3 letters is not commercially reasonable, and it's not going to be sufficient. And an insurance company will use it against you as having been committed fee forgiveness. So those are a couple things to keep in mind. And let's move on to the next topic here. John? There.
Thank you, Zach. And I just want to point out on the patient financial responsibility topic, that's always a hot topic. It's a topic that we've given entire presentations to. I mean, it's something that we could spend literally an hour getting into the weeds on that and all the legal theories that surround that issue that the payers assert and that we assert, and it's a very complicated area that has been litigated and is still being litigated all the time across the country. Number 3, in terms of our top 10, is pay attention to repricing agreements. So I'm sure everybody on the call knows what I mean by a repricing agreement. That's where you're dealing with some third party, like a multi-plan or Viant or one of those companies, who's essentially coming in and saying, hey, we will negotiate a price, a case rate or a rate agreement with you on behalf of the insurance company, and they often will say that they've got the authorization from the patient and all that stuff. The reason we included this in the list is because we've run into situations where clients are agreeing to things unwittingly. What often will happen is they'll get a stack of checks one day, and they'll start signing those checks, happy to have received money. But in that stack of checks, there was a letter that said, by signing these checks and by cashing them, you are essentially agreeing to XYZ terms. And it's just a bunch of fine print that often gets overlooked. So it's very important to make sure that you and your staff, your billing staff, your collection staff, understand exactly what's being agreed to when you're dealing with these repricing companies. I caution you be very careful about delegating authority to staff, because often if we get into one of these contracts and we want out, one of the arguments we're going to have to make is that, hey, the person who allegedly entered into the contract on behalf of our client actually wasn't authorized to bind their employer to this kind of contract. They never had that kind of authority, so this is not a real contract. But it's just very important to understand what's being agreed to. Understand, is it a case agreement or is it a rate agreement? A case agreement would be a one-off. We're agreeing to accept this amount of money for this particular case or this episode of care. A rate agreement is much larger than that, more significant than that. It's essentially you're entering into a rate, agreed on rate with that company. That company is then going to use to bring in other payers. So let's say you enter into a rate agreement with MultiPlan, then other insurance companies like perhaps United Healthcare or Anthem or whoever might have the ability to access that rate agreement. And so you're not in network per se, but it's sort of a quasi-network agreement that you've now entered into. And that's why it's so important to understand what is it that you're agreeing to, because it's usually not just a rate that you might be very happy about that you're agreeing to. You're agreeing to a whole bunch of other stuff including if there's disputes regarding payment, how are those disputes going to be resolved? Often those rate agreements will actually have specific terms that say you've got to go through that repricing company first and submit almost like a request for a dispute resolution. So they can slow down the process if you start having problems getting paid pursuant to the agreement that you just believed you entered into. It's also going to impact the ability to balance a bill. Now, that's usually something that people will understand when they sign one of these agreements. Hey, I can't balance bill this patient. But I've had situations where, certain types of providers, they rely on balance billing for patients. That's a big part of their revenue. And they might unwittingly enter into one of these rate agreements and think that they are agreeing to a rate only, and then lo and behold, they've just agreed not to balance bill any patients of any payer who accesses this rate. And that can be very, very problematic for a practice that relies on balance billing for that revenue. And we've had to represent clients in getting out of those types of agreements. So that's again, all I really want to emphasize, make sure people understand exactly what's being agreed to. If there's fine print, read the fine print. And lastly, keep records of these agreements. From the perspective of a litigator, again, Zach said at the outset, we're always, first thing we do when we get engaged is we start asking for all that documentation so we can see, all right, what can we prove? What can we prove in this case? And if my client comes to me and says, no, MultiPlan, they agreed to, 80% of bill charges, which I've seen before, then I need record of that. And it's not going to be good enough if all the communications with MultiPlan are happening through MultiPlan's online portal that you and I don't have access to at some point. So we need you to separately document and memorialize these agreements. Preferably we have things, contracts that are in writing and signed by both parties, but that's often not how it works in this industry. And so we at least need something that you're documenting contemporaneously with that agreement that's being reached. Okay, number 4, good clinical documentation. This is probably the most common sense of all of our top 10 list, and I think this is the one that our providers, our clients understand very, very well. but we have to always talk about it because it's so important. It's the most common reason that a payer or plan will deny claims or an alleged overpayment. The adage in healthcare is if it's not documented, then it did not happen. And if you've got missing treatment plans or missing signatures from therapists, or your discharge paperwork is not complete. Let's say the patient went AMA and it's not documented, or you've got all of your documentation just a boilerplate template where you're just filling in the patient's name and everything else stays exactly the same. All of these are issues that we see time and time again when we're fighting with the insurance companies. They're alleging that, nope, it's not enough documentation here to support the services that were billed. So, look, we're not, it's sort of we don't agree necessarily with the insurance companies in terms of the standard that they assert is necessary, but we also have seen some really poor documentation practices from providers. And so somewhere in the middle is really where you need to be. Obviously the closer you can get to the insurance company standards, the better. But you've got to make sure that you've got enough evidence in the documents to show that the services were rendered. Right now we've been in the midst of this COVID-19 crisis, and we've got a lot of people transitioning over to telehealth services. And there's going to be a lot of claims being submitted to insurance companies for telehealth that the insurance companies have not historically been receiving. So there's going to be a lot of denials. Denials could be intentional. Denials could be just as a result of the insurance companies just getting overwhelmed with these claims. But the documentation practices that you're keeping need to be carried over into telehealth services. The documentation must support the code that's being billed. So if you're billing group therapy, it's got to support that there was group therapy. All of the same requirements for in-person services are going to carry over to telehealth services if that's what you're doing. The coding is going to be a little different. It's a little tricky. I'm not going to get into the details of all the place of service codes and all that, but the documentation standards are going to be the same. And I can just tell you from experience, it's a lot better to be litigating whether services were medically necessary rather than whether the services were actually rendered. Because if we're litigating on, if the denial that we have is these services weren't necessary, we've got a leg up. We've got the provider and their professional judgment on our side who can say, this is all the different reasons why these services were necessary. But if we're having to litigate that whether the services were even rendered to begin with, because we don't have documentation to show that they were rendered, then more likely than not, we're going to be in a position of having to defend against a fraud claim being made by the insurance company. So good clinical documentation is absolutely critical.
Number 5, carefully document billing and appeals. My theory, my working assumption is that insurance companies are intentionally understaffing their claims handling departments. That when they lose your records or don't receive your records, or one hand not knowing what the other one is doing, that it may not be exactly on purpose, but they're certainly happy for it to happen, because the longer this confusion happens and the longer there's uncertainty and the longer it takes to process claims, the longer they're holding on to your money. So how do you deal with that? And by the way, I think that's particularly true once you're in prepayment review. I think the SIU departments, the investigation departments, are the guiltiest of all of this, and it's often the case, at least from my experience, that folks who are in prepayment review are just going to have a heck of a time getting anything to happen, because they'll submit medical records over and over and over again, and be told that they hadn't sent them in, or they sent them to the wrong place, or they've been lost, or we can't find them, or we scanned them in wrong, please resend them. And now, next thing you know, you've got 3 people working full time just to submit medical records, and that's not an accident. So what that means, and part of the strategy there, by the way, is, I believe, is to lull the providers to sleep, let's say, to make it harder and harder and harder to complete the process of submitting all these medical records, particularly in prepayment review, in the hope that a provider says, you know what, forget it. I've sent them in 3 times. If I don't get paid, I just got to move on to the next one now, and leaving that money on the table. And I think that's, again, it's no accident. So it's critical to stay vigilant. And the way to do that, aside from continuing to send in the records and hopefully having the resources to be able to do it, is to document everything. Document each and every submission, including the following information, including the original submission date, of whether it's the claim or the medical records. If you're in prepayment review, you'll want to know and keep a record of exactly what was submitted. It's best if you can retain an electronic image of what you're submitting. I've had it frequently happen that a client will have a record that, yeah, we sent in a fax on March 13th. I ask them, well, what'd you send in? They say, oh, I don't know. Well, how many pages was it? Well, it looks like it was 24 pages. Okay, which dates of service did it cover? I don't know. So it is best practice, in my view, to maintain a digital record of everything you're submitting, so you can pull up that March 11th submission and say, oh, it's dates of service August 3rd to August 10th. Perfect. You'll want to retain, if you faxed it, the fax confirmation. If you mailed it, you'll want to retain an image of the envelope as well. And if you've overnighted, you'll want to maintain the tracking information so you can confirm something was signed for or received. And you'll also want to record exactly where records are being sent. I have a litigation matter right now where my client, the provider, thought it would be helpful. They were in prepayment review to just go ahead and submit their medical record as basically right behind their claim. So they were submitting it to the claims department. And the insurance companies are arguing and saying, no, you were supposed to submit the claim to the claims department, the medical record to SIU. And that's a whole sticky problem, and it is difficult. I think we'll get past it, but I'd rather not have to deal with that issue in the first place. So you'll want to make sure you're sending your records to the right department or office or fax number or whatever it is, and that you're recording that you're doing it correctly. And then, of course, you'll also want to keep track of the submission date. And if it's multiple submissions, you'll want to have this for each and every time you're submitting something. That's as far as the document, retaining the documentation goes. But aside from retaining the documentation, it's also helpful to compile hard data. So I'll give you an example. When I litigate a case, it usually involves a number of claims. It can be hundreds of claims or more sometimes. And I try to reduce all that information to a single spreadsheet. I find that to be helpful for me, and I find it to be helpful to negotiate with the insurance company, and I find it to be helpful in terms of packaging it in the relatively unlikely event that we ever need to get to a trial and present a case to a judge or to a jury. I like to have everything on a single spreadsheet. And what my spreadsheet includes, and what I like my clients to be able to give me in a nice, neat package, the patient information, verification of benefit information, the representative from the insurance company, the reference number of the call, all the stuff I went through before, the basis of the out-of-network rate, the co-insurance, the remaining deductible and out-of-pocket, etc. The authorization information, the date, etc., and exactly what services and number of units were authorized. The dates of service, by individual unit. I know some folks retain their records by a claim, so it's often 3, 4, 5 units all together on a single line. I think it's much more helpful if you can create an individual line on the spreadsheet for each unit or each individual day of service. I'd love to have the CPT code or the revenue code for the service provided for each unit, the claim submission date, meaning when you sent in the claim, the medical record submission date, if there is one, for example, if you're in prepayment review, the billed amount, the allowed amount, if you can figure that out from the provider remittance advice, or if you have one, the paid amount, if there is one, and if nothing was paid, if the claim was denied, the denial codes and reasons, and any appeals date. And all of that on a single spreadsheet is the appeals date. And all of that on a single spreadsheet is save your attorney time in terms of packaging it up for a negotiation, for a settlement, or for litigating the matter if they have to. And I realize that a lot of this information you probably entrusted to a biller, whether it's an internal biller or an outside biller. And I understand that, and that may not be the focus of what you do day to day, but it is critical that you know exactly what your biller is doing and exactly what kind of record your biller is maintaining. It's ultimately, it's your business, and you need to be able to ensure that if you need that information, you'll be able to get it, whether from the outside biller or from your billing department internally or from wherever. That information is absolutely critical for you to collect down the road.
Okay. Yeah, that was a good segue, Zach. You mentioned the billers. So everyone's probably starting to pick up that while we call this a top 10 list, it's really just one thing, which is have great record keeping and documentation practices. And working with a good biller is essential in this area, because so much of this is going to fall on the shoulders of the biller. So we strongly encourage our clients to, whether you're working with an outside billing company or whether you're hiring an employee to handle the billing, to work with reputable and ethical billers who know the industry, know the codes, and this part is absolutely critical. You can keep up with the payers' ever-shifting reimbursement policies. When you're in network, you're more likely to be provided with copies of the payers' manuals and policies and their guidance, all the stuff that they're sending out. If you're in network, you're going to get that stuff. They're going to send it directly to you. So you're much more likely to be made aware of changes. For those of you who are out of network, you may be in network with certain payers and out of network with others. But when you're out of network, you're going to have a much harder time getting that information from the payers. So you have to affirmatively look for that information, and usually you don't look for it until your claims are being denied or you're notified of a prepayment review. And by that time, it's often too late. So it's important to work with a biller who's on their own initiative going to be out there keeping up with changes in the industry, keeping up with the payers' shifting guidance and policies, and feed that information back to the rest of the team who's involved in the billing and claims service, and really staying on top of those issues. Just think about right now what's happening with the COVID-19 crisis and all of this shifting over to telehealth. So insurance companies, they were pumping out new guidance probably on a daily, if maybe weekly basis. There was a lot of guidance coming out from all areas, from Medicare, from Medi-Cal, and all the privates, and it's just been a flurry of information. And I think that from our part, we've been trying to keep up with this information, and it's difficult to track, but we've kept up with it and we've summarized it in one location, and we're going to keep on going back and keeping up with it to see how it's changing. I would encourage that anybody who's working with insurance companies does the same thing, keeps track of what the insurance companies are doing, what they're saying, how they're shifting their guidance. It's not just enough to rely on the phone calls, the verification of benefit phone calls, the authorization phone calls. You need to be out there on their websites doing that research and figuring out what's going on, both right now during this crisis, but at any time really. And I also want to point out that unfortunately, when we do have to litigate a matter, we often find that we're litigating problems that could have been avoided had the biller been more on top of their responsibilities. what I mean by that is the issues that come up in litigation. Let me put it this way. Zach and I, we will probably spend more time speaking with the biller than we will with our client when we're litigating these reimbursement disputes, because the biller really was the one on the front lines. They were in the trenches dealing with it on a day-to-day basis. And so we get a very good inside picture as to whether that biller was doing a good job or a bad job. And often we will find that we have to clean up a mess that a bad biller created, whether it's through just incorrect coding. And in this particular industry, I find that most facilities rely on their billers to educate them and to decide what codes to use. That's different than a lot of other, like in the medical industry, medical practice. Most physicians learn their codes on their own and they select the codes. But I noticed in this industry, the billers are selecting codes. That's fine if they know what they're doing. That's great. But they need to know what they're doing, and you need to be careful, particularly if you're working with an outside billing company, that they're not selecting codes to just increase the percentage that they're gonna collect on. I mean because at the end of the day, if that becomes a problem, something like that would become a problem. That's going to fall on the provider, not the biller. The provider might have a cause of action against the biller in a separate dispute. But as far as the insurance company is concerned, that's the provider's problem. And if there's an overpaid claim, that's on the provider. They're not going to go after the biller for that. So it's always important to make sure you're working with good billers and staying on top of what it is that they're doing to make sure they're not incorrectly coding claims, that they're not billing for services that the facility is not authorized to provide, that they're not just engaging in some sort of automated billing process where I have seen situations where patients have been discharged for months, and that biller just every day just cranking out those claims, submitting those bills, and getting paid for them. For somebody who's been discharged for 2 months, I've seen that several times actually. That can be a big problem. And make sure that you know how much the biller is billing. Make sure you have that conversation. Don't leave it to the biller to just arbitrarily decide how much is going to be charged for a particular service. That should be a careful, well-educated conversation based on data, on market data. And then lastly, I want to point out, we'll spend a little more time on this, but make sure your biller stays on top of appeals. It's getting those appeals in timely and in writing.
Next topic, always be proactive. My guiding principle is that insurance companies are consistently seeing what they can get away with. And they do it in aggressive ways and passive aggressive ways. And some of these ones I've listed here are the key ones that we deal with on a regular basis. So the first one, prepayment review. Best advice I can give you is to get an attorney involved right away. You need to figure out why you've been put on prepayment review. It is oftentimes just a misunderstanding or something that can be very easily fixed. But I've seen far too often that providers just kind of accept it as a matter of course. Oh, rats, I'm in prepayment review now, without challenging it or asking questions or trying to figure out why, when all along it's something that they could have very easily fixed and would never have been an issue. You'll want to understand very clearly and in concrete terms, ideally in writing, what it's going to take for you to get out of prepayment. There's often some kind of metric, a percent of clean claims, for example. Of course, you'll want to get off of prepayment review as soon as possible. As we all know, it slows payment. It gives insurers an opportunity to find other problems that they may not have even known about. And it ultimately leads to denied claims. And of course, the same applies to pre-audit records requests. We see that increasingly, just sort of a vague request for records without any explanation why. And what we've come to learn is that is almost always the first step on a path to some kind of prepayment review, unless you're able to intervene, ideally, I believe, with an attorney, to figure out why those records are being requested, and to make sure that you are responding in a way that that sends home the right message. It strikes the right balance between being cooperative, but also showing that you're not just going to roll over and accept whatever the insurance company is asking of you. So there's a lot of strategy involved, and frequently what we find is that too much information can open the Pandora's box for finding new problems, but not enough information can seem like you're hiding something. So it's a very finesse-focused thing to respond to. Second, overpayment and recoupment requests. What we've seen, and again, this is something that we've seen increasingly, is that these are used as a tool, almost as I call it a scare tactic, to ask for, demand everything under the sun, knowing that, you know what, some poor suckers out there will probably just cough up the money. Well, don't be a sucker. I believe that these are often sent out even when the insurance company knows that there's no basis for it, or if there is a basis, that the dollar number is a fraction of what they are insisting you pay on. There are frequently very obvious problems with the recoupment request. There are very tight statutes of limitations on these things, meaning the insurance company can only look so far back to say we shouldn't have paid you for this claim. Well, you know what? You can only go back so far and point to a claim and say that was incorrectly paid, and now you have to pay us back for it. There are strict specificity requirements in terms of the insurance company explaining exactly why they think you owe the money back and exactly which claims you owe the money back for. And there's issues with exactly how the insurance company can recoup something, whether they can pull out of one pocket what they put into the other, whether they can recoup from a member from one plan for services provided to the member of a different plan, for example. And all sorts of technical arguments that can be made to defeat these recoupment demands. So don't be a sucker and don't just roll over. You'll need to dive into these things and figure out whether they're legitimate and how much, if anything, you actually owe. And then the last thing is to try to track any unusual reimbursement patterns. And I harken back to the spreadsheet of claims data I described before. And another important reason to maintain that kind of data is so that you can keep track of what's going on in real time. It's often the case that you'll crunch the numbers and see that, oh, you know what, for PHP, all of a sudden in 2018, I'm getting paid 50% less than I did the year before for a particular insurance company. I need to figure out why that is. Or that the supposed usual and customary rate for IOP at Cigna is half of what it used to be. That can't be right. Or suddenly a third of my claims are being denied when they weren't before. I better figure out why that is. I noticed that some claims were being denied. I didn't realize how systematic and broad it was until I actually looked at them. So it's critical to stay ahead of any changes in reimbursement patterns by being able to crunch your numbers on a regular basis to see if there's any unusual patterns out there that requires further investigation.
Number 8, when in doubt, send the appeal out. So I am a big proponent of written appeals. I've had too many cases over the years where the insurance company is defending on the grounds that there was no appeal submitted, and they will take the position that, sorry, that claim should be over. You didn't follow our administrative appeal process. Game over. Now, that's not a great defense by the insurance companies. Frankly, it's kind of a weak one, but I'd rather not have to deal with it at all. It's so much better when we get a case where the provider is very diligent about making timely written appeals of every, what I'm going to call a adverse benefit determination. That's kind of a term of art in the world of ERISA. we're not talking just exclusively about ERISA claims, but the point is, if the payer's made any kind of determination on your claim, okay, if they've denied the claim, whether it's a denial, normal automated processing, or if they deny the claim during the course of a prepayment review, they come back and say, hey, medical records just aren't, we flagged all these issues for you, your records just aren't quite meeting our standards, you're not getting to 80% of whatever you need, you're going to continue to submit records, you're going to continue to try to figure out what it is that is going to satisfy them to get you out of that prepayment review. But that does not mean you should not be appealing those denials while you're in prepayment review. Okay, so just because they say your records aren't good enough doesn't mean that you should just say, oh, okay, fine. You're going to be stuck in prepayment review for a while. And that's just what insurance companies do. There's ways to get out. We work with clients all the time to get them out. But you need to make sure that in the meantime, while you're there, you're appealing all of those denials. And you're appealing them with medical records. Unfortunately, you're going to have to resubmit those medical records, and you're going to have to explain why you believe those records support the services. If you get a payment that's too low, Zach was just talking about unusual payment patterns. All of a sudden you're seeing that your payments from a particular plan are dropping. You don't know why. Yes, you're going to pick up the phone, you're going to try to figure it out, but you still need to submit a written appeal contesting that underpayment. And if you get an overpayment alleged against you, you need to send a written appeal of that as well. There's multiple reasons why you would want to do that. One, if you don't, they often will just start recouping. They'll even tell you that when they send you the overpayment letter. They say, we expect to hear from you in 30 days. If you don't, they start recouping. That's what they'll do. So you want to get that timely written appeal or letter contesting the overpayment in. And frankly, it's an area that's kind of in flux in the law about whether an overpayment constitutes a adverse benefit determination that gives providers certain statutory appeal rights. Naturally, insurance companies are saying no, and folks like us who represent providers are saying yes. The courts have kind of been all over the place on it. It usually gets litigated in federal court, and so the law is in flux in that area. But in the meantime, always appeal. And in doubt, send the appeal out. We've touched on why it's important to appeal. In litigation, the insurance companies will say, yeah, you failed to exhaust the administrative remedies, and therefore your claims are barred. And that argument has a lot of traction if you're pursuing payment as an assignee of your patient's plan benefits. In other words, if you're basically saying, you're stepping into the shoes of the patient and you're saying, I have all the same rights and remedies that my patient had under their plan, under their insurance contract, and I'm pursuing that as an assignee of those rights, then guess what? That contract's going to say there's disputes, they have to be appealed through the insurance company's administrative process. And failure to do that is going to be a bar to the court even having jurisdiction over your claim. So it's a very important thing if you're envisioning potential litigation as an assignee. But it's also important before you even get to litigation and just negotiations with payers. Time and time again, they'll come back and say, I'll go to them and say, here's a big spreadsheet of unpaid claims. And they'll come back and say, these claims are 2 years old, they ain't get appealed. We're done. We're done talking to you. Want to go file a lawsuit? Go file a lawsuit. So don't lose that leverage that you're going to have in negotiations because you didn't bother to timely submit written appeals. And written appeals is key because if you just make phone calls, as valuable as making phone calls can be, and documenting those phone calls and what's said, that's not a substitute for sending a written appeal pursuant to the plan's appeal guidelines. Usually when you get a denial, it's going to say something about an address, an appeals department that you send in written appeals. Make sure that's where you're sending in those appeals. And by the way, when you send in these appeals, we think it's a good idea, a strategy, to request documents from the payer. Say, okay, you denied this claim for XYZ reasons. We want to see all the documentation that you relied on to make that denial. And by the way, we want to see a copy of the plan, the insurance contract. And there's a whole litany of things that you could ask for. they're not going to give it to you. I mean, they might give it to you if you actually submit your appeal with what's called a designation of authorized representative form that's being signed by your patient. They might give it to you then, but if you don't have that, they're not going to give you these documents. But what's important for us, from a pre-litigation perspective, is that you're now putting the insurance company on notice of this dispute, and you're putting them on notice that they need to maintain those documents. Because when we do get into litigation down the road, we make requests for documents. We're going to request all that same stuff. We want to see all the documentation that they relied on to make these determinations. They're going to come back, and they have come back often, and say, oh, well, you know what? We only keep documents for 6 months. Our email systems, and then they permanently delete. That's just our company-wide practice. Well, that's a huge problem for us if they're only keeping documents for 6 months. And so if you've already put them in notice as part of an appeal letter about your request for those documents, you might have a basis to allege that they've spoliated evidence by not preserving all those emails and other documents that are getting deleted. And last, let me just quickly mention: don't get bogged down though in endless appeals. So if the payer all of a sudden is talking to you, is negotiating with you, you think, oh, okay, you know what? They're coming around. They're going to pay me. They might, but they also might be just dragging out, running out the clock, because the statute of limitations is going to run from the time of that initial adverse benefit determination. It doesn't start running once all the appeal process is over. Once you've exhausted that appeal process, it runs from that denial. So, I've seen providers get sucked into 2 years of negotiating some denied claims, and then they sue on a implied contract theory in state court. After 2 years have gone by, well, guess what? Statute of limitations for an implied contract claim in California is 2 years. So their claims get time barred. Okay, number 9, move very quickly, we're almost out of time here. Don't sign insurer-prepared affidavits, and be wary of special investigation unit interviews. Basically, if you get into an SIU audit and they're requesting records, sometimes they'll include an affidavit for you to sign, this, affirming that all the records are true and correct, etc. Don't just sign insurer-prepared affidavits. Have that reviewed first, because first of all, you're not required to sign that. You don't need to give them free testimony on a disputed matter. You can send in your records, but you want to maintain the flexibility to send in additional records if it turns out that you actually find that, oh, you know what, we overlooked these records. Let's get those submitted later on. So you don't want it to suddenly say you're now giving them a complete, full set of records. And don't agree to any unannounced visits by SIU folks. I mean, I hear stories where they show up unannounced, knock on your door, wanting to come in. They act tough. They act like they're all law enforcement. And sometimes staff get scared, let them in, and these guys barge in, start taking a bunch of photos, asking employees a bunch of questions. And that's, again, you're just giving them free evidence. You're not under no obligation to agree to that SIU visit. I mean, unless you're in contract with them, and the contract specifically says they can show up and do unannounced visits. But without that, they don't have a right to walk in your premises. And while they're not law enforcement, they might be working with law enforcement. Okay, we see that all the time. The SIU folks are working with law enforcement. They're feeding information to law enforcement. The SIU is doing all the heavy lifting, and then you just let them come in and essentially execute a warrantless search of your premises. So if SIU shows up, call your lawyers, get counsel involved right away.
The last point I want to make here is keep your friends close and your enemies closer. And really, most importantly, with respect to your biller, what I find is that it can take a long time for you to realize you have a reimbursement issue that you want to pursue. And it can take even longer once you've identified that issue to actually resolve it. It can take a very long time, even if you're not litigating it, even if you're just trying to resolve it informally. It can take many, many months or longer to get it resolved. And what we find all too often is when we need to go and produce data or billing records or something to resolve a dispute, you say, hey, can we get your biller's phone number? And they say, oh, you know what? We actually changed billers 3 months ago, or a biller retired, or whatever. and it becomes very difficult to find those records. So the challenge is, if you're, particularly with respect to outside billing companies, if you are making a change, you need to make sure that you are getting back all of your billing records. And it's a massive job. It can be a multi-day job going to that biller's office and making sure you walk away with a drive of all of your billing records, all of your data, everything that you could ever possibly need a year from now, 3 years from now, if you're going to need to go and support those claims in some kind of reimbursement dispute, or if the insurance company comes after you with a recoupment demand, you're going to want to make sure you have access to all that stuff. And all too often we hear, oh, the biller said, don't worry, just give her a call and we'll take care of it. Or, we're leaving on good terms. And then 2 years down the road, you know what, they really don't want to be hassled by you because they're not getting paid. So make sure you've got all those records when you are moving on to a different biller. And the same goes with the employees as they're leaving. Make sure they leave happy. You never know. It turns out that former employees are often the most frequent whistleblower candidates. So it invariably happens that key witnesses, key employees leave. Do your best that they leave happy, that you're not burning bridges. And in any kind of business divorce, if you are splitting with a business partner, you'll want to do as best you can to work into any divorce separation agreement how you're going to handle recoupment demands down the road, how you're going to handle future reimbursements that trickle in, particularly if you've been in SIU and those reimbursements are delayed. How are you going to divide them up? How are you going to account for them? Make sure that works its way into your agreement so you're not fighting about it down the road. Angie?
Yep, sorry. Wasn't sure if you're done. We do have a few questions that came in during the chat. While we are answering those, if you have any further questions, please put them in the chat room. Early on, you had briefly mentioned, can we play clients' premiums? And they said they are hoping for more information on that.
So my general answer is you're buying a problem if you do it. It is viewed typically, just in the abstract, it's viewed as an inducement. There are ways that you can by clearly documenting, for example, that it's that you are advancing the money and that the client who you're doing this for is going to pay you back, and it's with some kind of secured, say, a promissory note or something like that. And you certainly would never want to do it before they were in your facility. I think the only time it is even remotely safe to do is if they're already there, and then suddenly have this need arise. I would say you can mitigate there, and then suddenly have this need arise. I would say you can mitigate your risk by making sure you can document that you have secured their debt to you, and that you will at least attempt to be repaid on that money down the road. But my overall advice is that it is buying a problem, and
I agree with 100% with Zach. It's there's a law, federal law, the ECRA law that came out in 2018 that addresses that issue, and it's essentially pretty much prohibited under that law. And then the insurance companies, they are aware of this issue, and they ask questions about it. And I've actually negotiated settlement agreements with insurance companies where they will insert that as like a requirement that even if the provider never did that, they'll insert as a requirement, like going forward, make sure you're not paying any premiums for the members of that insurance company. So,
okay. And then the next, another question. Will you address methods of overpayment assessment, i.e. RAT stats or 100% claim reviews by insurance companies on PPR?
I'm not sure I know what the question is in terms of RAT stats and PPR. I've had a lot of clients get into PPR, and we've worked with them to get out of PPR. It can be a long arduous process. The one area I touched on during the presentation is, is making sure that even when you're in PPR, that you're still appealing the denials. What happens when you're in PPR? I'm sure everybody probably knows this, but your claims are essentially being taken out of the automated processing queue and stuck into a different queue, into a manual processing queue. And now you've got to submit records to support your claim before it gets paid, as opposed to the normal process. And you're going to get scored on how thorough your records are. Are you meeting the insurance company's standards? Usually, when I see folks get into PPR, the insurance companies flag certain issues. Like they've already said, this is why you're in PPR. Like we're putting you on PPR for these codes for this reason. At least they should, and you should be asking for that. If you get stuck in PPR and you're not getting any information as to why, you should be hiring an attorney to get that information, so that you know what you sort of know what you're looking to do, what you're looking to achieve. And it can be a process of just working with all of the clinicians in your program and the billers and the physicians who are your medical directors, and just making sure everybody's understanding, hey, there's something that's not getting documented the right way, and we need to work on this. And at some point, hopefully, you're going to be submitting, the insurance company is going to see enough records that they say, okay, we're comfortable and confident that they're now complying with our standards. What won't work is if you get into PPR and then you just figure out what the issue is, but then you hold on to a bunch of claims. Because the way PPR works, at least most of the insurance companies I've dealt with, when they finally let you out of PPR, there's going to be an effective date. They're going to say, okay, as of January 1, 2020, you're out of PPR. But every single claim with the date of service before January 1, 2020 is still going to be subject to the PPR. So even if you're now out of PPR for ongoing future claims, all those old claims still have to go through that submission process and be supported by medical records. So you haven't done anything by holding on to claims. You should be submitting your claims on a fairly timely basis. And that's how, of course, you're going to get the score that you need to get out. Now, I can't speak for each insurance company in terms of what their scores are and their metrics and how they make those determinations and the volume of claims. I don't know. That's a conversation that you should be having when you're into PPR with either the SIU folks or one of their reviewers. But I can tell you that you need to be submitting enough volume of claims that they're going to say, okay, you've met our metrics, let's let them out. So I hope that answers the question. I'm not sure that's exactly what the question was. Whoever's asking the question.
They did clarify they did clarify RAT stats used by some insurance companies to extrapolate claims review and project overpayments versus actuals from 100% review.
Yeah. Hi, this is Zach. I can tag a little bit onto that. I tend to be skeptical of the extrapolation methodologies they use, particularly for projecting overpayments. That's usually the first thing we push back on when we get some kind of overpayment demand. So that's that piece of it. However, I've also encountered the notion of extrapolating from a sample to resolve an SIU dispute. In other words, to get somebody out of SIU, right? That there's usually a percentage. If you can have 80% clean claims, well, the suggestion sometimes comes up, well, let's pull 20 examples and see if it meets the test. And I'm in theory open to that idea, although I'm just a suspicious person by nature, and I want to make sure that I am involved in identifying the sample set and in the methodology for picking a sample and extrapolating from it. But I am open to the idea in the context of getting out of SIU. I don't like it just as a rule when it comes to projecting over.
And then we have one final question. As planned G&A departments and SIUs are separate, will a favorable finding by the G&A appeals usurp on continuing SIU investigation into a similar overpayment matter?
Angie, could you broke up for there a second. Can you repeat that question real quick? I didn't.
Yeah. As plan GNAs, departments, and SIUs are separate, will favorable finding by the GNA appeals usurp on continuing SIU investigation into a similar overpayment matter? And I'll copy it and paste it back into the chat room as well.
Okay. Zach, you were about to start speaking. So
I think the answer there, I think the answer there is maybe at some point way down the road, but the practical answer is who cares? I mean, I get the issue that, right, that an appeal team may come up with an outcome for a particular issue, and it might contradict what SIU has decided for that same issue. And yeah, if you're gonna litigate the issue, or you're gonna have a protracted back and forth making this point, well, your appeals team said differently. They found in our favor, the SIU should too. Yeah, there might be some traction there, and in court there probably would be some traction there, but you're so far down the road and have spent so much money fighting about it that I just think that practically speaking, you're still going to end up fighting both fronts, and it's going to be a long time until you're able to use the finding of one department against the finding of the other.
Yeah, I've seen this issue come up, and the departments themselves, the SIU says, oh, well, we don't control them, we don't control appeals, and the appeals will say, oh, well, SIU, we haven't heard that. I think, I mean, my feeling is that you definitely want to raise it. You certainly want to, if you're getting conflicting information, conflicting findings from different units of an insurance company, you want to document all of that. And when you submit your appeals, whether it's an appeal to the claims appeal, normal appeal process, you're going to want to have the documentation of what the SIU folks told you. If they told you something in writing and you got it in writing from them, an email or letter, you're certainly going to want to use that as an appeal. So, will that cause the overturn? I mean, I'm very cynical. I'm a big proponent of making appeals, but I'm thinking from the perspective of I'm going to have to litigate this anyhow. I actually don't think that appeals are very functionally successful to get paid. I mean, I just feel like they're just rubber stamped denial, deny the appeal on a without somebody actually looking at it. But you still got to do the process.
Okay. Well, looks like that's all the questions. I want to thank John A. Mills and Zachary Rothenberg for presenting today. Thanks as well to everyone in our audience for participating. A reminder that a link to access both the webinar and the PDF of the slides will be sent in the next few days from an email ending with bhap.us. This will include some things that I put in the chat room that were brought up during the presentation, including a prior webinar we did specifically on the documentation of medical necessity, as well as a link to one of our associate members, which deals with billings. We are also keeping, we hope that you join us for future BHAP webinars. You can sign up for our various newsletters, which includes emails specific to upcoming events at our website, www.bhap.us. We are also keeping a list of resources related to COVID-19 and behavioral health industry on our website, including other webinars that we've done and one that's coming next week on telehealth. This concludes today's webinar. Thank you very much.